All right, and well, this is what has been happening this week in a week in review, and one of the main things that has come up is the amendment that has been proposed by Jubilee to some of the laws in regards to the election. Of course, it has met a lot of resistance from the opposition, but the question, of course, that is left for Wanjiku is who does it benefit? Let's listen to what some of the leaders had to say over the week.
Any more laws to give Kenyans an election on 26th of October. But if Parliament passes the laws, I've also said, I hope those laws will not change the framework we have put in place.
Right, so that's the chair of the IEBC, Wafula Chebukati, basically saying we do not need any more laws to have the presidential re-election that is scheduled in another 25 days. And that's what we'd like to talk about. But before we get to that particular amendment, gentlemen and your lawyers, and I would like to find out from you, because at the end of the day, we do know that courts can be abused, courts can be misused, courts are there to arbitrate. Have we, as Kenyans, become so legalistic to a point where you and I, Dr. Mukhwana, or you and I, Alex, cannot have a civil agreement based on our value system, based on moral conscience, based on just the basic human fundamentals that are required, to a point where now the court has become the main thing? Your comments, and maybe what the court is really meant there for.
Yes, Michael, let me begin by saying this, and I should be forgiven for saying this, that I think as Kenyans, we are too materialistic. Our values in this country are based on materials. If I came into the Standard Media Group walking or on a boda, my class is degraded.
You're already categorized right from the point where you're coming into.
Precisely. If I came in here without a particular type of designer shoe, my class is categorized. Now, this is what we Kenyans have become. We are very materialistic. The days when what was in your soul, what was in your manners, what was in your spirit was important, long escaped through the window. And so, Kenyans as a society are in a rat race to make money, howsoever obtained. So much so that it has reached a level where it is power that you require so as to amass the money. And therefore, as long as you have acquired the money, nobody looks at how you've acquired that money, and that's not important. Therefore, our race towards making money and material acquisition has clouded everything, including our political psyche as a nation. And therefore, when you see two protagonists fighting, one side versus the other, and shortly you see even those who are on the other side quickly crossing over and telling you that I feel now I should work with this side, it is not about the values of the Constitution rest on the other side or this other side. Not at all. It's about that is how he'll pay his bills. How do you explain, for instance, the greatest respect to the Luhya community? How do you explain a situation where an immediate sitting governor who was opposing the other side quickly crosses and says, this is the man this is the party that should have been here for the last 5 years. What has changed after he lost an election?
In a few days.
In a few days. How do you explain a situation where, with the greatest respect to our former speaker, Ken Marende, a man who performed the best duty as a speaker in a polarized parliament, actually, in my estimation, he performed better than, you can only compare him to the late Jean Seroney. How does he not stand out at this hour and give direction to where the country is headed without looking at Jubilee
or NASA or whoever else?
Or whoever. It's because the bills matter. What does not matter is the Constitution. And therefore, when we shall be looking at these amendments and the reason, please look at these amendments in that light. That what matters to our politicians now is how they'll pay their bills.
Okay. Your comments before now we go to the actual amendments.
I don't think Dr. Mukhwana, with all due respect, has given your question due regard and attention. Because I think you asked a very simple question. You asked, have Kenyans become too litigious? I think that's what, and I believe that the reason why you asked that is in the light of the fact that there are so many cases in court in regard to the electioneering process that we are undergoing.
Correct.
If I'm not wrong, I think that's what you meant.
Yes.
I think, Michael, if you ask me, I would rather we have too many cases in court regarding any issue on electioneering process, rather than have none at all and resolve those issues on the streets. So I would rather that we are fighting in court on a particular issue regarding electoral process, or maybe validity of a step that has been taken by the electoral body, or maybe one of the parties, or a participant or an actor in the electoral process, for example, the police in terms of the security, rather than have Wanjiku or NASA or Jubilee take the issue to the street.
Allow me to pose you, and that is true.
Yes.
That is a good way to have it, that we're in court rather than on the street.
Yes.
But the question also, and that I think is what Dr. Mukwana was referring to, what has made us get to a point where you and I cannot sit down and, guided by our values and morality, agree on something?
Let me, if you allow me to interject there. The reason why I took a bit of time and appear to be sidetracking from your question is to lay a background as to why we end up in court. That, you see, a court is meant to be the final arbiter, and it only comes in when there's disagreements. Why we in court all the time, or most of the time, is because we are disagreeing all the time. Why are we disagreeing all the time? Because our values are upside down. That is why I was creating that background.
In a nutshell.
Yes, please proceed.
Carry on.
Now, I think the question itself has a solution to what you are saying. Remember, this issue of alternative dispute resolution, ADR, is anchored as a public policy in the Constitution itself, such that you do not need even to go to the court. Under the Constitution, you don't need to go to court for you to resolve an issue or a dispute that you have with your neighbor, or with your partner, or with whoever you entered an enterprise with. So the Constitution itself, as a policy, as a principle, as a matter of public policy, recognizes the importance of resolving dispute outside the mainstream of the courts. So that one has been taken care of. Secondly, even when you go to court, the first question that you are asked by the presiding officer, for example, the judge, is, have you tried to resolve this issue out of court? Secondly, you must indicate to court, for example, in your pleadings, what steps did you take before coming to court towards resolving this dispute? So such that at the end of the day, Michael, what ends up in court is a reflection of two parties or protagonists who are unable to resolve their dispute outside the mechanism that has been laid within our judiciary. So I think I wouldn't worry so much, because, as I said earlier, let people go and fight in court rather than
go on the street.
Yes.
All right. Because of